Hello, everyone. I'm JD Shi with Jiaquan IP Law. Thank you so much for joining us today at the webinar, Application of Patent Intelligence, How to Use Patent Intelligence to Improve the Efficiency of Research and Development. During the presentation, if you have any questions, please feel free to leave them at the chat box, and we'll try to answer them as many as possible. If the time is limited, we'll provide full answers to your questions afterwards. Now, I'm very honored to welcome our speaker today, Ms. Ronnie Zhou. Ronnie is a very experienced patent attorney and attorney at law. She's also the manager of the Search and Analysis Department of Jiaquan IP Law. Now, let's welcome Ronnie.
Hi. Thank you all so much for joining today's webinar. I'm Ronnie.
Hi, Ronnie.
Hi.
Yeah, my name is Kwon from Ken Fox IP Law Office. Hi, Zodi.
Hello. Hi, Chair.
Yeah.
Good to see you.
Yeah.
Nice to meet you.
Nice to meet you.
Okay. May I start the session?
Yes, please.
Yes, please. Yeah.
Okay,
Go
thank you.
ahead, Ronnie. Thank you.
Okay. Can you see my PPT?
Yes.
Yep.
I see on my screen. Yeah.
Good. Okay.
Yes, we can see.
Okay, good. The reason I proposed this discussion topic is that I've noticed that both my foreign and domestic clients have shown great interest in using patent information to promote R&D in the past few years. And we found that using patent information in the early and middle stage of R&D can play a significant role and help save more time and money throughout the entire product R&D process. So through my experience, I've witnessed firsthand how patent intelligence can be a game changer in R&D. In this 45 minutes session, I guess, we will explore the key ways patent intelligence can fuel R&D efforts. And we will look at real-world cases. And I think I will also share some practical tools that you can take away and apply immediately. When my clients come to me with questions about using patent info to help with R&D directions, besides listening to the specific needs and goals, I usually ask them what stages of R&D they are at. For us, different R&D stages might mean using different ways to help clients solve different kinds of R&D problems. For example, if a client just has a basic R&D idea but no specific technical plan or product yet, our goal is probably to help them understand how others in the industry are making similar products. They can then know which directions to go in. While doing this, they need to avoid patents set by competitors and make their products unique. But if the client already has a very mature or specific technical plan, their need might be how to figure out a clear patent risk in this field. And before the product is finally molded or launched, they should do some design work to avoid these risky patents. The focus of our work may lie in interpreting the claims and technical features and brainstorming together to come up with some small alternative technical solutions that can help us avoid these specific risky patents. So today, based on my practical experience, I'm dividing my session into 4 parts. The first is the setting stage. During the process, there are 4 stages that company often go through during the R&D process. The first is setting stage, and the second one is determination stage, and the third one is formulation stage, and finally the product has been developed and the product is going to be launched. So next I'm going to explain stage by stage During this process, I will talk about what problems companies might facing in different R&D stages and how we can help them solve these problems by using patent intelligence. And I will also incorporate these explanations into specific cases to make it easier for you guys to understand. So let's get started. In the setting stage, we will dive into crucial factors that determine whether an R&D project is truly necessary. We will analyze market trends to see if there is a demand for new product improvement. For example, if the market is saturated with similar products, we need to figure out if our R&D can bring something unique to the table. Well, identifying competitors is also very important for any R&D project. I will share with you how to use patent databases as a powerful tool to find out who's already working in the same area. For example, you might discover through patent searches that your competitor holds a rather special technology, which will force you to look for alternative solution. This analysis also helps in setting realistic goals for you to for your own R&D, so you can differentiate your product in the market. Well, the patent searches and analysis, we can not only analyze the necessity of R&D, but also see what our competitors are up to. This helps us explore more R&D directions better. Based on this, we can try to figure out our actual R&D foundations. Maybe there are some existing technologies we can use. These are like freebies. If we can do that, we can save both R&D costs and time. Well, the first story I want to tell is about the emergence of a new idea for keyboard. Starting from about 5 or 6 years ago, people, especially those who type on the computer all day, they really like using mechanical keyboard. I'm a mechanical keyboard user. The good touch feeling and the click sound make typing very enjoyable. Also, mechanical keyboard have a very important user group, game players. Mechanical keyboards may have some advantages over traditional keyboards in terms of rebound and response speed. So a client of mine who is in the keyboard business came to consult me. He wants to develop a product for players who care about gaming experience or operational performance. This product is supposed to be able to display the user's hand operation speed in real time on the keyboard. Basically, they intend to develop a keyboard that can show the APM value, which is the action per minute value on the keyboard. My client and I basically knew that there were already some similar products on the market, but just in small quantities. Through our communications, we identified the problems our entire project need to solve and come up with 3 questions. The first is, do the existing products on the market have corresponding patents to protect them? And the second, if we want to develop such a product, from which perspective can we do to differentiate our product from the existing ones? The third, which technology do we need to develop independently, and which technology can we potentially borrow without risk? Okay, now let's solve these problems one by one and see how we can at least partially answer these questions through patent intelligence. Okay, there is no no animation. So before starting the patent search, we first conducted a market survey on products. Through our search, we found there were at least 3 products on the market that could display the APM value on the keyboard in some way. For example, the first one, the well-known company Razer has a product that can display changes in a player's APM value through an APM lighting system. It shows different colors of lights to do this. And we also found that there is a company named Dongguan Mingguan. They set up an LCD screen on the palm rest of the keyboard to display the APM value. Another well-known Chinese keyboard making company, Ripple, they also did a similar product. It's like the Razer. It mainly set up APM breathing lights. The APM information is displayed through the frequency of breathing lights, and the brightness can also be adjusted. So through this product survey, we directly learned how our competitors are in this category. It can also provide us an entry point for our subsequent patent search. So I directly showed the simplest search process. For the applicants, I used the company names of the 3 competitors we found. Since I was looking for the keyboard product, I entered the word keyboard in the title and abstract fields. And because the core point of our whole solution is its ability to display the APM value, so I entered APM in the TACD field, which is title, abstract, claim, and description. This is the simplest search. Through the search, we found that Razer has actually filed 2 patent families to protect its related product. I want to say, in the actual search process, the search formula we use is much more complicated. We will do more expansions. For example, expanding on the subsidiaries and patent companies of the applicants. At the same time, we may also expand on keywords such as APM by finding its synonyms to ensure that we can search all relevant patents. Yeah, through our search, we've confirmed that for the first product, there are corresponding patent layouts to protect it. So it gives us a certain amount of risky warning. This way, we can constantly keep in mind that the patents that our competitors have filed during the R&D process and try to avoid them as much as possible right from the R&D stage. It is imaginable that there must be some other companies in Chinese market that also have ideas about this APM keyboard and have filed for some patents. They may not have mature products yet, but they may have already filed for patents to protect their ideas. So after expanding our search, we did find some other patents. I put a part of them in the table. After reading and analyzing the patents, we found that the vast majority of the applicants still present APM information to users through a numerical display or lightning display. So next, we sit down with the engineers and conduct in-depth analysis of the specific technical solutions involved in these patents. We checked one by one from which R&D directions these applicants actually implemented this APM display function. Even for numerical display, methods of display, the ways of measure APM and how to present it are different among companies. During this process, the engineers can clearly understand what others have done, and they will gain some inspiration and also try to make some differences from the current technical solutions in the patents when conducting subsequent R&D. And at the same time, we also had an unexpected discovery. We found that there are some companies also display this APM value on the mouse. We also explained this new idea to our clients, and they were quite interested in it. It may be an inspiration for their R&D. When solving the second problem, we found that among the patents related to the APM keyboard, most of the patents regarding the keyboard structure designs are already in a state of they are expired. For these invalid patents, they can actually be used, and the risk of infringement is relatively low. If the engineers don't have too many innovative ideas in terms of structure, they can try to refer to these structural designs in these invalid patents. However, we found that some patents regarding APM detection, the circuit structure design inside the keyboard, and the APM display in different scenarios are still in a valid state. So our engineer may need to invest more in research and development in these directions. Well, in most cases, companies actually have a clear R&D theme. However, the R&D direction and the specific technical route to be adopted may not be determined in the early stage. So based on the demand of many companies, we will also help our clients to evaluate the feasibility of various R&D directions and find an R&D path suitable for the companies through using the patent intelligence during the R&D stage. Well, my second story is about a product that is very popular today, which is the new energy electric vehicle. Among the technologies of new energy electric vehicles, one is particularly important, and that is C2B technology. That is cell-to-body technology. It breaks the physical boundaries between the traditional battery pack and the vehicle body by directly integrating the battery cells into the vehicle body structure, thus achieving higher structural strength, space, using rate and energy density. My client is a very mature automobile company in the gas field. But in the past 3 years, it has gradually been developing its new energy vehicle models, and it is very interested in the C2B technology. Since they don't produce batteries, so the key point of their R&D is still on the C2B technology itself. Therefore, they hope that we can help them analyze what kind of technical route they should take to develop the C2B technology so as to achieve results more quickly and try to distinguish their technical route from that of other relatively mature new energy vehicle manufacturers in the industry as much as possible. Well, there are a large number of new energy vehicle companies in China. As far as I know, there are at least 3 main R&D directions for the C2B technology. For example, there is solution proposed by BYD, and the other one proposed by Tesla. There are quite obvious differences in their overall technical ideas. So my client is very concerned about the R&D trends of different C2B directions. And my client wants to know what the advantages and disadvantages of different C2B implementation methods, as well as what the latest technology is like. When we were doing the patent analysis, we definitely need to search for our target patents. In order to help clients determine in which directions they should conduct R&D, we should at least first understand what existing patents there are in the technical field of C2B and how they are distributed. So after we have obtained some relevant C2B patents, what we want to do is how to analyze the layout of these patents. Then we think maybe we can placing them on a timeline, we can understand the evolving trend of these technologies in different technical directions or the R&D route of different companies. When we were doing the technical decomposition and the classification, we did encounter some difficulties. First of all, we need to determine a technical classification system or a framework of C2B technology. And then based on this framework, assign the patents we searched to the corresponding technical directions. In Chinese, we always say that the technical branches However, we found that if we use a purely technical division of C2B technology to create such a technical framework, many patents are difficult to be assigned to a specific technical direction. For example, some patents describe a complete frame structure or a system that combines the battery and chassis. They may not be able to attribute to a specific technical direction. And it is also difficult to determine the more detailed technical directions. We discussed the problems we encountered with the client, and we jointly proposed a rather innovative solution. That is, we use a technical effects as the top level technical directions and then decompose them layer by layer. Our basis for the decomposition is what the specific technical means we can use to achieve such a technical effect. And then we create a framework of the technical directions and the technical effects. Just as we can see in this picture, the first level technical direction is the technical effect we proposed, taking enhancing collision safety as an example. For a second level technical direction and the third level technical direction, we have respectively proposed technical solutions or structural designs corresponding to the technical effect of improving collision safety. In the actual process of decomposition and analysis, the technical directions involved increase level by level. Here I'm only showing a part of it to show how we can gradually obtain the distribution of the patent in this field and sort them out. In this way, when the client is actually conducting the R&D and wants to know through which structural designs or software designs they can achieve the improvement of collision safety, they can start from the first level technical direction and gradually find the technical solutions they are concerned about. And they can see how others have done in the direction of improving collision safety and what the technical routes are. And then we gradually extracted some representative and some important technologies that appeared each year and form such a table. Well, the first row is the time axis, and below it, we specifically listed patent information such as the theme applicants and corresponding publication number. Here, we also add a field about the citation frequency because for some very key and breakthrough technologies, the citation frequency is likely to be relatively high, and more people will pay attention to this patent. When we were selecting important patents, the citation frequency was also a very important reference basis. And at the same time, we also summarized the technical beneficial effects of each selected representative patent. To make it easier for everybody to see the trend of technical development, I enlarged the bottom part of the picture. As you can see, the technologies in the blue frame represent relatively mature R&D directions. The technologies in red frame represent the current mainstream R&D directions, and the yellow ones are the emerging directions that everyone is currently researching and developing. Overall, we found that in the technical field of improving collision safety, from 2011 to 2022, it mainly developed along such a technical route. Before 2011, it mainly improved the collision safety by enhancing the structural strength of the vehicle body frame. Then from around 2012 and 16, the R&D focus on the research on the energy absorbing components. From 2016 to 2020, the R&D focus more on structural strength of battery frames. This is not involved structural design, but also the emergence of some new materials. It is through this method we have sorted out the technical solutions of each patent and every technical effect. In this way, we can clearly understand the entire technological R&D path and what the key focuses of R&D are at different stages. At the same time, we can also combine the client's own R&D foundation, R&D advantages, and their preferred R&D directions to evaluate their R&D strength and progress in the specific technical directions and figure out what position they are in the industry. This can provide them with certain information and references for their subsequent R&D investments. Meanwhile, the client can also understand how other competitors conduct R&D and to a certain extent improving their R&D efficiency by reading patents. In actual work, I found that few clients are aware of using patent search and analysis and patent intelligence to promote R&D in the very, very early stage of development. More clients usually come to us when they are in the later stage of R&D. And at this point, they already have some clear R&D solution. They may need our IP team to help them identify the innovation points in their solutions. These points can be used as selling points for advertising the market or for patent applications to better protect their products. Since the technical solution already have a prototype, clients may be more concerned about potential infringement risk. Even in the later stage of R&D, they may have some specific technical problems that haven't been well solved. They hope to solve these practical R&D problems through patent analysis and intelligence. Well, the third story I'd like to share with you is about an R&D of an e-cigarette. A client of mine wants to focus on developing a microwave heated e-cigarette. As we all know, the most common types of e-cigarettes on the market are atomized cigarettes or HNB, which is heat not burning e-cigarettes that using heating plates. Now the direction of the product he wants to develop in the future is microwave heating. Microwave heating definitely has some special advantages, so he thinks this is an important development direction for his future products. However, during the R&D process, they found that in the technical field of microwave heated e-cigarettes, their competitors have already filed some very core and important patents. Moreover, the application dates of these patents are early. If they develop the product according to their original technical plan, they are likely to face significant infringement risk. So they came to us and hoping that we could explore other technical implementation methods together with them. And in this way, they can not only solve the technical problems, but also reduce the infringement risk to some extent. When facing such a task or even a challenge, I think our way to solve the problem is very clear. First of all, we want to see if we can help the client find, of course, in the technical field of e-cigarettes, other ways to achieve the microwave heating that are completely different from the patents filed by the competitors. Because my client has a direct competing relationship with the competitor, so it is difficult for my client to obtain a patent license or legally using the technology. However, if there are some new technical solutions developed by other companies in this field, there is a great possibility of cooperation between them. Unfortunately, after searching in the e-cigarette field, we don't think there are other technical solutions to avoid the competitors' patents. So next, we will expand the search scope to microwave ovens. Because in terms of the principle of microwave heating, e-cigarette and microwave oven almost have the same working principle. After all, microwave heated e-cigarette is a newly emerging and relatively niche field, and the patent layout and R&D may not be very mature. But in the technical field of microwave ovens, which has been developed for many years, there may be some technical solutions that can bring more inspiration and help to the client's R&D. Yes, finally, we did find several patents that can provide some very practical inspiration for the client's R&D. I guess if we haven't found any inspiring or helpful patents in the microwave ovens field, we might have further expanded the search scope to the field of microwave heating technology. Maybe not just limited to microwave ovens as a product or application scenarios. Well, the three patents presented on the page are some of the inspiring ones we found. None of these patents have been directly applied in the technical field of microwave heating for e-cigarette. Instead, they are mainly in the technical field of microwave oven heat. They can partly solve the technical problems the client is currently facing. Also, they adopt technical plans different from those of the client's competitors. And I believe everyone may be curious whether these three patents will lead to new infringement risk. Well, in the process of searching, we tried our best to provide some patents that have already expired for clients' reference and inspiration, but sometimes the result may not be as satisfactory as we hoped. Some patents may still be invalid, and their technical plans may be very helpful to the client. And in this case, there may be some infringement risk, but our top priority is to solve the threat from competitors directly faced in the e-cigarette field. As for the subsequent infringement risk brought by these patents, we can solve them in the future. After a long R&D process, we finally have a product prototype, and at this stage, companies may be more concerned about the infringement risk of this actual product and how to reduce them when the product is sold around the world. The fourth story I'd like to share is about the R&D process of sweeping robot. And recently, sweeping robots have been really popular. Dyson is good at developing handheld vacuum cleaners. And in Chinese market, the most popular type is the floor sweeping robot. It is like a disc that can move around on the floor and sweeping the dust. It can automatically transport the dust back to its base station, and it can also clean its floor brush and the mop, the mop underneath. My client referred to the best-selling sweeping robot of his competitor and develop a similar product. He also knows that his competitor has filed some patents, so he's worried that this product may face a lot of infringement risk after it goes to the market. So he came to me with his product and its design and asked if I could help him conduct a comprehensive patent search on this competitor's product from start to finish. And he wants to know how to do the final avoidance design before mold opening so as to reduce this infringement risk as much as possible. Actually, in principle, the control of infringement risk should be carried out in the early or middle stage of R&D. Because once the product has a very clear design, it may be more difficult to make changes to the product during the mold opening stage. And once the product has been mold opened, changing the product structure will incur very high costs. So generally, I highly recommend that clients carry out control of an infringement risk in the early and middle stage of R&D. But faced with the current situation, I need to find a way to help the client solve this infringement risk problems as much as possible. So what did we do? First of all, for sweeping robot, although it appears to be a product on the outside, it's actually composed of many technical details inside. For example, there are structural design of water tanks and the sweeping brushes. There are also many control methods and like path planning methods, since patents usually focus on protecting a specific structure or specific control method. During the writing process, we need to break down the product into many technical directions or technical branches. In this way, after we search and find many patents related to the competitor's product, we can align these patents to different technical directions according to the product design. Only in this way can we help the client understand what the risk patterns are in each structure or method and how high the risks are. However, I need to point out that for some very mature and structural designs, such as the design of the shape of the sweeping brush or the design of the dust collecting box, perhaps all products on the market adopt basically the same design. For such structures, the infringement risk for the client may be relatively low. And some very innovative designs or functional designs that obviously have beneficial effects may be the focus of patent protection by competitors. So the infringement risk of such structural designs and control methods will be relatively higher. Once we have determined the key and risky technical directions we want to search for, we can start the patent search. Since we have very clear competitors, it will be relatively easier to find these risky patents within a defined scope. After we find the patents related to the products, we need to compare them with the client's current product structure and their control method to determine which patent are potential risky patents. Well, so that's all I want to share about how patent intelligence promotes R&D. And I believe that you may find aspects of yourself in these 4 stories and maybe realize that other companies or people are facing the same problems as you do. Okay, so if you have any specific questions, maybe we can we can communicate. You can leave them in the comment section.
Hi, Ronnie. Thank you so much for the excellent presentation. Could you please see the checkbox? I see some colleagues have left their questions.
Okay, the first question is, our client applied for patent containing cannabis as one of the companies.
Hi, Ronnie.
Hi.
Yeah, my name is Quân from Canfox IP Law Office in Vietnam, and thank you so much for your excellent presentation. I have a question, but it is not so related to the topic of our today presentation. So I think JD has said that this question may be saved for later. Mr. Jason may answer this question because maybe it relates to the another technical issues, the cannabis, and I think that the question here from Ms. Yo asking about the databases you use in your work in the searches or conducting some searches. We want to know about the database or even the tools, how you can where you can use it to support the search work or some analytical tasks. Can you share with us? For example, even the AI or other tools you use in the work.
Okay, I can share with you some database I use every day. I think there are many database are highly user-friendly today. For example, PetSnap, in Chinese 智慧牙 PetSnap, PATSNAP, and IncoPet. These are two databases I use every day. And I think they are offering comprehensive data with fast updates and very simple user interfaces. And they integrate some AI functions in the database, like AI search, AI analysis, and AI summarization. They said their database can comprehensively solve all kinds of your patent problems. And they even said they are trying to developing the function for patent application drafting and all office action response. So maybe that's to the tools I use every day. Pattern Snap and IncoPat.
Yeah.
And yeah. And do you know in China there is very popular tool called DeepSeek? It's similar to
Yeah, about the DeepSeek. Yeah.
Yeah. I use DeepSeek every day to do some background knowledge search like that.
I wonder whether AI can be used for patent examination in China. How AI is used by the CNIPA in examining the IP subject matters, the IP application file with the CNIPA. Do you think that the AI can be used to examine the IP application to render more precise rulings or examination report?
As far as I know, AI is not permitted in the patent examination right now, because maybe a month ago there is an office action. There is some screenshot of DeepSeek because the examiner used the DeepSeek to do the examination and screenshot the answers of DeepSeek on the office action. And this office action is has a very bad influence in Chinese IP IP world. Yeah, so as far as I know, AI is not permitted in patent examination right now, but I'm not sure in the future.
Yes, I think that in the future, AI will be very helpful in conducting even the CNIPA or the National IP Authority can make more investment in creating the AI tools to help to facilitate the examination, even effectively conduct the substantive examination, and even to issue the more accurate rulings or examination report for the complicated IP issues like patent. Yes,
Hello.
thank you so much for your answer.
Yes.
Yeah.
Hello, Ronnie. Hello.
Hi.
Hi. Yes. I'm also from Kinfox IP Law in Office from Vietnam. And may I turn back to your first story, or the first story of the keyboard case?
Sure.
Yes. In the APM keyboard case, my question here is, how can we distinguish between the truly novel patentable features and the minor design variation that are unlikely to be granted patents?
Could you
Yes.
repeat your questions?
Yeah. Yes. For the first story, yes. Thank you for your information about the keyboard development. That is one of the most inventive tools that we are using today. Okay. Yes. And my question here is, in what way can we distinguish between the truly novel patentable features and the minor, the very teeny design variation that are not likely to be patented?
So your question is how to distinguish the patents with really the patents is highly innovative and the patents that are not shouldn't be patented, right?
Yes, right.
So your question is how to make sure the technology in the patent are the real technology can be used by practical R&D, right?
Exactly. Yes. I wonder if there is any creation any real creation here?
Okay. Yes. I think that's a very good question because I at the maybe the first or the 2 years of my career, I always find some patents and provide the patents to the clients and said these patents are very.
Lebih dicari kat mana?
Hello?
Yes.
Okay. At the first beginning years, I always provide some patents. I think they are very innovative to the clients, but engineers of clients said they are not true technologies. The technologies cannot be used in practical R&D or practical production. So in recent years, I always have a very deep communication with my client before starting the search work. I will have a very comprehensive understanding of the field I will search. And then maybe I will provide a list of the patents I think that are very close to their R&D direction. And the client's engineers will read the patents themselves and give me some feedback. And during this whole process, I understand what kind of patents and what kind of technologies they really need. So I think the best way to solve this problem is to doing the search and analyzing work with clients, engineers together. By ourselves, maybe are not enough.
Okay, so to what extent can the backward and the forward citation analysis help us evaluate the maturity of specific R&D paths within the keyboard technologies? Yes, you mentioned we may rely on the analysis in the R&D, right? So how or to what extent can the backward and the forward citation analysis help us examine or evaluate the maturity of the specific R&D paths within the APM keyboard technology?
You mean how to use the citation frequency as the basis to do the patent analysis?
Yes. Okay. Yes. In what way? Right.
Well, I think the citation frequency is just one element, because with higher the patents with higher citation frequency means they have the technologies can be seen by which is more important. But we also use some other elements like patent family, the number of patent family, or 还有I think whether it has any litigation history. We will use all kinds of elements to decide whether this patent is important or not.
Yes. Okay. Okay. Thank you very much.
You're welcome.
Ronnie, do you have any time to answer the questions from Duck Dao or Rina? They have asked several at the chat box.
Yes, I'm checking it. So, Duck Dao's question is regarding the technical effect approach you discussed. Could you please elaborate on the specific reasons for choosing this method? Additionally, what are the advantages of this approach compared to the other two? Okay, so you are talking about you are saying we choose the technical effect as the first layer technical direction, but we didn't choose technical problems or technical means, right? That's because in most cases we will choose technical means or technical solution as the framework of our technical analysis basis because but in this C2B field, we first tried the technical means, but it doesn't work. So we switched to the technical effects. And the second reason we use this method is because our client is concerned about the technical effects of the C2B technology itself. So we switch our way to solving the problem. I think that's because we did a lot of work in practical work. So yeah, I think because we couldn't make it work by using technical means, so we switched to the technical effects.
Hello, Ronnie. Can I speak,
Hi.
please?
Hi.
Ronnie, I have a question. I have a patent to be registered in China. I'm living in China, actually. Then I already registered it in the US as a provisional. My question is, if I register in China, as I understood, China Patent Center will publish it as fast as I apply. Then I don't want it to be published because my invention is a quite new green energy, is new source of energy. So I am scared to be published and be copied. This is one question. How can I be protected? If I apply in China Patent Center, they will publish it. I'm not in safe side anymore. Second, how can I trust your law firm to apply for me? And how can I be sure if your law firm cannot leak my invention? Because it's quite huge. I have no money to even make prototype, can make a prototype, but even for registration, your law firm and things don't have investment. But the idea, if I say 100% sure, you will say it is bullshit. But anyway, it's a quite serious business. So how can I feel quite relaxed to ask your firm to register for me, even I find a investment to pay your law firm to just apply for me in patent center in China, and how can I be sure if your patent, if your law office cannot leak the information? One question. Second question is, I'm not happy if the Chinese patent center just publish it. Then what can I do? How can I be safe if I just want to get a patent without publishing? Thank you very much, Ronnie.
I think I understand your concern. For your first question, I think if you're worried that your technical solution is leaked, I think you don't have to worry it because we will assign the agreement, the confidential agreement before you filing any technical materials to us. So we have the agreement. For the second one, I think the patent around the whole world, their principle is, or the principle is using the publication to have the protection. So if you want to, your technical solution is protected by patent law, you have to accept that your solution is published. I think if maybe you have some specific ways to delay the publication. Maybe there are some way you can do it, but it will be published in the end.
Ronnie, this is Philip. Can I add something?
Sure, go ahead.
Yeah, Ronnie, thanks, JD. In terms of the U.S. provisional application, Baram, you have 1 year after the initial filing in the United States to convert that into a utility application. Otherwise, that provisional thing goes away. You don't have a right whatsoever. So don't consider that as a you have filed a provision, excuse me, a provisional, and you're safe. You really need to think about that within 1 year from the initial filing. Otherwise, that is gone. That is not a patent right. That's just a ticket to hold a place for you to convert that into a utility or invention patent in the US. And further to what Ronnie said, yes, if you engage with any law firm, any reputable law firm in China, such as Jiaquan here or any other firms, they are bound by the attorney-client confidentiality agreements. You can rest assured that this is they play ball by the highest integrity level. You don't have to worry about that. That's my comment. Thank you, sir.
Thank you, Philip.
Thank you very much. Thank you very much for your comment. I know this 1 year for provisional patent, of course, then I have at least 1 year, I'm in safe side. I have 1 year to just make it as a the patent, real patent. But anyway,
Otherwise,
thank you very much. Thank you very much. But
thank you,
anyway,
Bara.
yeah, it was my concern. Actually, Ronnie, the law firm, I really somehow, okay, the agreement you told me, okay, there is no any other way to just go on. So I have to just make agreement, sign, and trust, and be sure to not be leaked before get in production, get hold the market, and things like that. So anyway, because whatever come out, it comes all the copy, and everything is production, is a money. The production can make a generator, just make whatever, means electric generator everywhere, can make it with a new source of energy. So that's why it's a little bit tricky. But thank you very much for your comment and for your suggestion. Okay. Anyway, if Ronnie let me know, then we could be somehow in private. Then maybe we could somehow discuss how can I asked you to apply for China Patent Center without get any harm from my invention to be leaked and to be copied before I get all the commercial throughout my patent. Thank you very much.
Thank you.
Ronnie,
Mhm.
Ronnie, this is Abu from Pakistan. Just a follow-up thing from Behram's comment. Can you hear me?
Yes, yes, I can hear you.
Yes, I think what I may be sensing from Behram's here is that there seems to be a sense of decoupling of scientific advancements going on between the US and China, at least when it comes to very high-end technologies. Whether that's AI or whether that's something got to do with renewables or electric vehicles or batteries or stuff like that. Now, if you have something at the end, there's really, and if you go on to publish that or patent that, it's effectively no longer decoupled. And that means that, somebody, an individual like Behram or anyone else for that matter, is going to have, a very difficult time trying to fight against any kind of infringements that he's probably not going to be able to prove. And this then brings into question the basically scope of IP law firms in both countries, the US and China itself. And so if somebody's worked out something really remarkable, he or she is going to be thinking very seriously about how to basically whether to patent that, whether to put that in the sort of knowledge pool, or to pull out some connection directly with a Chinese or a US large enterprise corporation where that invention and that work can actually be directly translated into revenue. So maybe I think that's what Behram perhaps is trying to refer to.
Yes. Hi, JD.
Hello, yes.
Hi. Could you answer the question from Abu?
Well, Abu, could you please leave us a message later? We could try to answer your questions in full by email. Is that okay for you?
Sure, I will. Sure. Thank
Okay.
you.
Okay.
Yeah, because I think your question is complicated.
Yeah, we will need some time to digest your questions and provide a better answer because the
Right.
yeah, it's a little bit limited. Yeah, so thank you, Ronnie, for answering almost all the questions, but we'll still take some time later. Yes, so thank you all for the participation at the webinar. You have made the past hour so meaningful and productive for today. So later we will send you the copy of Ronnie's presentation and also the link of this webinar. Thank you all for your kind joining with us and sharing your insights about patent search and how to use patent intelligence to boost the research and development. So that's all for today, and hope to see you next time for our coming webinar in trademarks, customs sessions, and also some patent practice. We'll send you the notice if we have set up the date and time.
Thank you, Ronnie.
Thank you,
Ronnie.
Thank you, guys.
Ronnie. Thank you, JD.
Thank you, JD.
Very good. Thank you.
Thank you.
Mm-hmm.
Okay.
Thank you,
bye-bye.
everyone.
Wish you a
Thank you,
good day.
Ronnie.
Have the
Bye.
rest, of
Can we
the day.
gather for a photo?
Of course, why not?